ask each of our participants, and I understand all four of them are here today, to go ahead and spend about 15 minutes giving you their perspectives on the topic. We're going to basically go from left to right, starting with Samantha Power at the Carr Center for Human Rights at Harvard University.
Okay, we were tasked to talk about legal developments and moral dilemmas, and I want to talk about, if I could, the politics of enforcement. Because in many of the other sessions we've been talking about law, international humanitarian law, laws against genocide, universal jurisdiction, but the domestic piece, or the political piece, often gets left out of the equation. So what I thought I would do is go over some of the cases, specifically looking at the U.S. response to genocide. Just taking one country response. I'm doing a book currently on the subject called The Quiet Americans, on U.S. responses to genocide since the Holocaust. Any discussion of genocide, I think, has to begin at the source, and the source being a man who some of you are probably familiar with, Lindh, who in 1933 stood up at an international law conference in Madrid, a legal relations conference of lawyers, and attempted to ban the practice of what he then called barbarity and vandalism. Barbarity being the physical destruction of ethnic groups, religious groups, national groups. Vandalism being the cultural accompaniments thereof. Lindh was sort of simultaneously laughed and yawned out of the conference, told that the crime that he was describing took place too seldom to legislate, and that it was clearly just a sort of Jewish conspiracy, really, to just protect Jewish groups behind national lines. Lindh was a childhood atrocity buff and not altogether devout or practicing at all, and was actually much more consumed with the ongoing destruction of the Armenians than any potential threat to the Jews. But he went back to Poland, and 49 members of his family were exterminated. He ended up a refugee, landed in the shores of this country in 1942, and spent the years between 1942 and 1944 believing and telling himself that if he'd only had a better word to describe the destruction of groups, it would have all been so very different, that perhaps the lawyers would have taken him more seriously. And if you look through his notebooks, it's sort of a fascinating journey. There's one page where he writes in his scrawl the word, draws a circle around it, and then draws a line to two words in big capital letters, moral judgment. He felt like you had to find a word that had inherent within it a kind of moral judgment. Apart from the legal piece of it, which he never lost sight of, adding the practice was always his end, he also thought there was something very, very important in sort of the political kind of collateral damage the word could do. And so he came up with the word genocide in 1944, then spent the next 4 years battling behind the scenes to try to team up with some lawyers at the United Nations to get a drafting convention passed. Pestered people like Ben Ferenz in Nuremberg to try to get an indictment, a genocide indictment, included in the list of crimes. But really thought, in terms of enforcement, not just enforcement in courts and specifically in domestic courts, which is what the convention stipulated. He also thought of the International Court of Justice route, that states would file genocide charges or genocide applications before the International Court of Justice, and that the ICJ would weigh in on those. But he thought that would take too long, that by the time those judgments were passed, genocide would long have been committed. So his notion was that actually the General Assembly and the Security Council of the United Nations would be the principal forum. He did not think in terms of military intervention. He did not think of the Genocide Convention as necessitating that. He knew that no state would ever tie its hands to sort of commit itself ahead of time to some form of military intervention. And also at that time, the notion of interventions violating state sovereignty on behalf of humanitarian principles was a little far-fetched. Just because I know it's going to come up later, and probably in Pierre's talk, he had a more expansive conception of genocide than we do, I think, today. He, as many of us know, he didn't think in terms of extermination, nor does the convention. It's framed in terms of destruction, multiple forms of destruction. But if you look at his kind of lobbying activities before his death in 1959, he actually, one of the things he argued for was that what Korea was doing was a form of genocide. And it's very hard to know whether he actually believed that or whether he was trying to secure South Korea's ratification by arguing that. One of the things he was trying to do was cobble together enough ratifiers to make the convention law and then to ensure that those ratifications stuck. But anyway, I want to begin with a discussion of Lemkin because I think as I look anyway at U.S. policy, military, legal, economic, political, public responses to genocide, the sort of Lemkinian instinct about what the word genocide could mean and the kind of moral judgment that attaches to it, I think is quite relevant. The first case I think is worth looking at is the U.S. relationship to the Genocide Convention itself. This was a relationship that was a troubled one, initially great enthusiasm from President Truman and actually from the Senate Foreign Relations Committee. But the convention ended up languishing for several reasons, mainly rooted in a kind of vocal minority that opposed it for a whole series of reasons, many of which foreshadow the opposition to the International Criminal Court today. For 40 years, the ratification was bogged down on a number of grounds. One was early on in the 1950s and 60s, a conception that because the term genocide was indeterminate, that Southern senators who believed in Jim Crow or who were presiding over segregated school systems could be accused of genocide because they were inflicting mental harm on various ethnic groups, and so arguably that was a form of destruction. This was the argument, or that people on the outside would make that argument. The second was one we hear today, which is a fear that U.S. soldiers similarly would be hauled before distant courts on account of genocide charges, even if they hadn't committed it. Again, the term was indeterminate. It could be a lowest common denominator document, and the U.S. Senate really didn't want to leave the determination of when genocide was committed or whether U.S. soldiers had committed it to outside parties. There were concerns about federal intrusion on state prerogative, and of course, familiar concerns about U.S. sovereignty and a desire to avoid any constraint really on U.S. state practice. So the convention languished for 40 years. There was a tipping point of sorts in the early 1980s, and it stemmed from a number of forces, and I think it's worth sort of unpacking. One was an ad hoc coalition came together of NGOs, religious, women's, labor groups in this country, quite actually reminiscent of a kind of coalition that Lemkin himself had cobbled together in the 1940s. And this group at least posted the letterhead to be able to make the claim that they spoke for enough people that votes might actually be secured if ratification went forward. The second is advocates of the Genocide Convention began to frame it in the late 1970s as a tool in the Cold War struggle. That is, it would become humiliating for U.S. diplomats to stand up in international forum and criticize the Soviet Union for the abuses, human rights abuses it was committing, because the retort was always, yeah, well, you haven't even ratified the Genocide Convention, so how are you speaking? And this, again, in the Reagan era was persuasive, I think, to some of his advisors. The actual Reagan's decision to throw his relative weight behind the Genocide Convention took place also on the eve of the 1984 election. The announcement was made at a speech at the Nye Breath, and this was where the candidates, I guess every 4 years, come to try to persuade Jewish voters to vote for them, and there was some notion that you could secure votes in this way. But the main thing was that there was a recognition that one could ratify the convention really at no risk to U.S. soldiers. One could actually guard against many of the fears that had been articulated. So enough reservations, understandings, and declarations were attached that the U.S. ratification basically was sort of symbolic. The U.S. Did not submit to compulsory jurisdiction of the International Court of Justice if a state filed genocide charges against the United States or submitted an application to the ICJ. The U.S. was not bound to it, and so it felt like it could sort of sign on to the convention and reap potentially the Jewish votes and the diplomatic sort of assets or perks of ratification without forfeiting anything in the process in the way of sovereignty. Just to look briefly at the cases, which I think when one looks at the cases of genocide that have happened since the Holocaust, in looking at, again, multiple layers of response and multiple sectors where one might have expected a response or some notion of enforcing the norm, one sees a kind of all systems failure. And I think that's worth pointing out. Certainly a failure of leadership, but also a failure among journalists. I myself was a journalist in Bosnia. among NGOs in certain instances, and among constituencies that one might expect to generate some kind of public oomph on behalf of the norm. Looking first at Cambodia, U.S. policy response to Cambodia was seen almost entirely through the prism of Vietnam, or not seen. The constituency that one might have expected to carry the day, or at least to generate some kind of concern or public outrage in the period between 1975 and 1979, or in the early years specifically, this constituency was very skeptical of the rumors that emerged from behind Khmer Rouge lines. There was a notion that almost anything that coincided with what Nixon and Ford and Kissinger had predicted would happen was necessarily suspect. So, and this was not altogether surprising, and journalists were sort of trained to get first-hand accounts, and much of what was emerging was rumor. But over time, they did gradually come to believe, but not for the first 2 years. The first 2 years, the sort of press response was very, very light coverage, and the public response was next to no interest and really significant skepticism about the reports. The executive itself wanted to turn away, and the State Department wanted to turn away, even though, in fact, events confirmed earlier logic about what the communists would do if they took power. There was a desire to turn away because any attention to the neighborhood would remind constituents and the American public of what had just gone on. There was no desire to do that. So there was a real kind of reluctance to look squarely at the reports that were emerging. And again, having gone through a lot of cable traffic and of the time, there was a real awareness among U.S. officials at the border about what was going on the basis of refugee testimony, but still a kind of plausible deniability born of not being able to access the country in question up close. In terms of the genocide debate, it's quite interesting to see this debate proceed over time. Already then, although the word is only 3 decades old and not as prominent a part of our lexicon as it is today, there was a live debate about whether genocide was occurring. It was not. It was born mainly of skepticism, again, about refugee reports and about whether the numbers of dead that were being alleged were accurate and whether the crimes would rise to the level of genocide. There were also questions about intent, about whether Khmer Rouge possessed the necessary intent to destroy a particular ethnic, national, religious group. And specifically, there were some who argued that, in fact, at the time, even before one got a sense of the scale of the deaths, that because intellectuals were being targeted, or people who were perceived to be bourgeois, people who had a 7th grade education, that was a political group, and as we know, political groups are excluded from the Genocide Convention, from the protections of the Genocide Convention. So the debate was a little more legalistic once the scale of the killing became clear. There were no congressional hearings on the genocide in Cambodia in 1975 or 76. They began slowly in 77, 78, and then of course, when Vietnam invaded and dislodged the Khmer Rouge, the U.S. Maintained recognition of the genocidal regime in lieu of recognizing Vietnam, a U.S. foe, and in the interest of respecting the wishes of China, which had just become an ally. Second case, briefly, what I look at is that of the gassing of the Kurds in northern Iraq in 1987, 1988. Again, I think you see a pattern. Similar, I would say disappointing, retrospectively anyway, coverage on the part of the press. Only 2 real instances, though the destruction campaign goes on for about 18 months, only 2 instances of concerted press coverage, one in March of 1988 and the other in September of 88, and really only when refugees end up on the right side of the border, not surprisingly, into Turkey in September 88 and into Iran in March of 88. There's a notion, again, these events, as Cambodian events, were processed through the prism of Vietnam. These were processed through the prism of the Iran-Iraq War, both in terms of American national interest in propping up Iraq and not allowing Iran to emerge victorious, and a conception that the Kurds were insurgents and rebelling against a state, and that there was legitimate repression that could be, if not condoned, at least understood. The effort to enforce the Genocide Convention, if you want to call it that, was really more an effort to enforce the norm against genocide. There was no real legalistic conception of the convention at this time in policy circles, but there was a legislative effort to impose sanctions against Hussein, and it was called the Prevention of Genocide Act, which was introduced in September of 1988 by Claiborne Pell, spearheaded by Peter Galbraith behind the scenes. Initially, a constituency was actually mustered on behalf of this convention because of the use specifically of chemical weapons against the Kurds. Galbraith and Pell and others were very skillful in kind of bringing together people who actually didn't really care that much about what was happening to the Kurds, but did care an awful lot about getting the chemical genie back in the bottle. And so they did initially get a law through the Senate, but then again, ultimately the vocal minority spoke up, and in this instance, the Sanctions Bill, the Prevention of Genocide Act, would have stripped Saddam Hussein of a $500 million agricultural credit that Hussein used to support American farm products. So the American farm lobby and manufacturing lobby also protested as for import bank credit suspension and strict geopolitical interests. Sincere and conservative State Department and White House opposition to the sanctions package. One, to the notion of Congress making foreign policy in the first place, as well as that opposition. But two, much more fundamentally, a sense that the carrot approach with Saddam at that time was more appropriate. Again, the State Department and White House utterly resisted the use of the term genocide in this instance on the basis of intent. Their claim was that the intent of Saddam was to put down an insurgency and not to destroy the rural Kurdish populace. I'm running out of time, so I just want to go briefly through the last two cases. Rwanda, many of you know more about, perhaps because it's more recent. This, again, was seen very much through the prism of Somalia, and Cambodia through Vietnam, the Kurds through Iran, Iraq, and through Somalia. There's no contemplation in U.S. circles of a U.S. troop role, whatever revisionist claims might be to the contrary. There's no U.S. actor who lobbied with any sincerity at any juncture for U.S. troop presence. There was next to no one who argued for reinforcing the UN troop presence on the ground. There was almost full support for the UN withdrawal, the 90% cut in the UN troop presence that took place 3 weeks into the genocide, or 2 weeks into the genocide. There was also a refusal in U.S. governmental circles to jam Rwandan radio broadcasts, and as we know, a refusal to use the term genocide. I do want to stress there was no policy cleft at all in the U.S. government. There was not a single cabinet-level meeting in the U.S. government for the 100 days that the genocide proceeded, not one cabinet-level meeting. As a result, Pentagon opposition and skepticism about United Nations generally, but UN involvement in Rwanda particularly, carried the day. I just want to read you something, and then I'm going to do Bosnia in a split second. I think people would be interested in this. This is a May 1 discussion paper on Rwanda issued by the Office of the Secretary of Defense, and it ran down a list of the options that were being mooted at the time as to how to respond to genocide. Again, I think it is important to think about responses on a continuum of intervention. Military intervention is the most robust form, of course, prosecution after the fact, but then a whole series of measures that could be conducted ahead of time. This is the Secretary of Defense's response to a list of the proposals, so his office's response. And first I'll read what the proposal is and then the OSD response. 1, genocide investigation. Language that calls for an international investigation of human rights abuses and possible violations of the Genocide Convention. That's the proposal. Response. Be careful. Legal Department of State was worried about this yesterday. Genocide finding could commit USG to actually, quote, do something. 2, counter-propaganda. This is again the proposal. Should the U.S. engage in additional propaganda activities to get a message into Rwanda to counter the radio stations that are urging the killing? OSD response. This is a significant increase in our role. Suggest that we offer equipment to neighbors and urge them to do it. 3, pressure to punish organizers of killings. Something that's come up in this conference a great deal already. OSD response, no, capital letters, no. Hold till ceasefire has been established. Don't want to scare off the participants. I mentioned all systems fair. It's worth noting briefly on Rwanda, there was no constituency for action. There was not only no policy cleft, press coverage again was poor, a lot of tribal imagery and very little talk of atrocity in the first month of the war. Much of the coverage came from outside, from Kenya, and on the basis of relatively uninformed accounts of what was going on inside. The Congressional Black Caucus at the time, which one might have expected to become later a constituency for caring about Rwanda, was very silent at the time, very busy with Haiti, in fact, doing protests and getting arrested and things outside the White House. Alison Ford from Human Rights Watch, when she went to meet with Tony Lake in the midst of the genocide, was asked Lake what he thought people on the outside should do, and he said, make more noise. The phones aren't ringing. The phones didn't ring throughout the whole Rwandan genocide. Finally, in the case of Bosnia, and then I'll just wrap, this was very much seen not through a recent prism so much, I think, as the prism of World War I and then World War II. There was a huge policy cleft in the Bosnia case. More resignations from the State Department than one had seen in the Vietnam War, which I think is notable. There was strong editorial support for bombing, strong congressional support, steady press coverage, but again, strong deference to the Pentagon, the president with an uneasy relationship with the Pentagon, and a deference to the European opposition. People talk a lot about the Rwanda, the U.S. government's avoidance of use of Lincoln's word in the Rwanda case. Very few talk about it in the Bosnia case, but there are unbelievable debates between Congressman McCloskey and Secretary Christopher on the Hill successively throughout 1993 and early 1994 about use of the G word, in which Christopher does what he had instructed people in the State Department to do in Rwanda genocide, which is to avoid use of the term. In the end, intervention in Bosnia, we know, does come in August, September 95. I think because, again, the political calculation has changed. After Srebrenica, there's a notion that Clinton himself is being personally embarrassed, that the international order has been assaulted as a result of the massacres. Clinton's line on it to an advisor at the time was, "We're getting creamed." Never mind the Bosnians. There was also a notion that U.S. peacekeepers would have to get involved anyway to extract European peacekeepers. So there was a sense of inevitability of U.S. involvement, which changed the calculus. And of course, there was a 1996 election coming. In any event, I wanted to go through that account because I think we need to think about the politics of enforcement and how one can change the calculus that seems to be made on an individual level. Often what one finds in going into the kind of black box and seeing how these responses are generated is the sum of individual decisions by individuals making highly personal, political, and institutional calculations. And it seems that one has to, as a sort of first cut, think about how to tinker with the way those calculations are made and create some cost to inaction, whereas now there's only a conception of a cost or a risk of cost for action.
Let's now turn to Jerry Fowler, who's the staff director at the U.S. Holocaust Museum Committee on Conscience and formerly with the Lawyers Committee on Human Rights.
Thank you, Paul. Thank all of you for coming. I'm very happy that I get to go after Samantha because I would like to essentially accept and incorporate by reference everything that she's just said. It provides, I think, a good backdrop for what I want to talk about, which is the role of memory and conscience in combating genocide, or the role that those two things haven't yet played, but perhaps potentially could play. As Paul said, I'm the staff director of the Committee on Conscience at the United States Holocaust Memorial Museum in Washington. And the mandate of the committee is to alert the national conscience and influence policymakers to confront in order to halt acts of contemporary genocide and related crimes against humanity. The source of this committee and the source of this mandate goes back to 1979, when the President's Commission on the Holocaust, which was chaired by Elie Wiesel, reported to the President on appropriate ways for the United States to memorialize the Holocaust. The core of their recommendation was the creation of a living memorial, part of which was a memorial museum. And that's what most people associate with the Holocaust Museum today, is the building and the permanent exhibition on the Holocaust. But they also recommended, as part of the living memorial, a Committee on Conscience. In their report, they discussed the importance of having a memorial museum. They discussed the importance of having education be part of that. But then they turned to another issue. And they said that of all the issues they had looked at, none, this is a quote, was as perplexing or as urgent as the need to ensure that such a totally inhuman assault as the Holocaust, or any partial version thereof, never recurs. This was in 1979, and they said, quote, "The Commission was burdened by the knowledge that 35 years of post-Holocaust history testify to how little has been learned. Only a conscious, concerted attempt to learn from past errors can prevent recurrence to any racial, religious, ethnic, or national group." And they concluded very strongly that a memorial unresponsive to the future would also violate the memory of the past. So they felt from the very beginning of envisioning this institution, the Holocaust Museum, that it had to address contemporary issues. And their suggestion for a vehicle for that was the Committee on Conscience. Just somewhat parenthetically, for a variety of reasons I don't have time to get into, the committee was actually not created until after the museum was opened. The museum was opened in 1993. The committee was established in 1995. I joined the staff of the museum as the first permanent staff member dedicated to that function about a year ago. So this has been a long, drawn-out process. But one thing that has struck me is first that the President's Commission felt so strongly about that need to address contemporary issues. And secondly, how common that idea is. The idea that memory both can and should speak to conscience, and that should in turn lead to action. And in fact, somewhat in spite of the facts, the history that Samantha has just run over for us, the conventional wisdom of that idea has been articulated by successive presidents, people who were in office during the events that she was just talking about. And in fact, the words are carved on the wall of the Holocaust Memorial Museum in Washington from the 39th President of the United States. And I'll leave names out of it because it's not that important. The 39th President of the United States put it clear, it was in 1979. Out of our memory of the Holocaust, we must forge an unshakable oath with all civilized people that never again will the world stand silent. Never again will the world fail to act in time to prevent this terrible crime of genocide. We must harness the outrage of our memories. The 40th President of the United States in 1988, we who did not go their way owe them this. We must make sure that their deaths have posthumous meaning. We must make sure that from now until the end of days, all humankind stares this evil in the face, and only then can we be sure that it will never rise again. The 41st President of the United States. Here, talking about the museum, we will learn that each of us bears responsibility for our actions and our failure to act. Here, we will learn that we must intervene when we see evil arise. Here, we will learn more about the moral compass by which we navigate our lives and by which countries will navigate the future. All of those words that I read, that I just read, are literally carved in stone on the outside of the Holocaust Memorial Museum. And the reader of these presidential words merely has to turn around and she can see the core of our identity as a nation, of our American identity, the Washington Monument, the Lincoln Memorial, the Jefferson Memorial. And by virtue of the identity of the people who said those words and the place where they've been inscribed for posterity, it's fair to think that these words have some fundamental truth. But yet we have the history that Samantha has just gone over for us, and we can't help but conclude that as frequently as those sentiments seem to be expressed, they're also ignored. And it has occurred to me many times, working at that particular area, that there's a very fine line between inspiration and mockery, something that is underscored by the fact that within 2 years of the museum's opening, we had Rwanda and we had Srebrenica. Michael Ignatieff has expressed, I think, very succinctly the limits of memory and conscience in responding to genocide and mass violence. He said, quote, "When conscience is the only linkage between rich and poor, north and south, zones of safety and zones of danger, it is a weak link indeed." Unfortunately, sometimes that seems to be the core link, this link of conscience. The political calculus that people are making, that Samantha referred to, is dominated often by interests that aren't necessarily implicated by the violence that is occurring. And the basic challenge that we face at the museum, if we're serious about the mission that was first articulated by the President's Commission in 1979, is amplifying the voice of conscience. It's been said that conscience whispers while interest screams aloud. And so what we see is the role of the museum is to amplify the voice of conscience above a whisper and help it compete a little bit more with the volume of interests. Some of the challenges, though, that are presented in full force in trying to fulfill that mission are illustrated by a recent decision that the Committee on Conscience made to take up the issue of Sudan, the situation in Sudan, where some 2 million people have died in the last 17 years, and more than 4 million have been driven from their homes. Just very quickly, I want to highlight some of the things about that situation that led us to take it up. Basically, actions of the government that caused the committee to decide that it's something that the museum and the Committee on Conscience should focus on in a determined way. Some of those actions by the government are a divide-to-destroy strategy that they've pursued fairly resolutely of pitting ethnic groups against each other with tremendous loss of civilian life. The use of mass starvation of civilians as a weapon of destruction. Toleration of the enslavement of women and children by government-allied militias. The incessant bombing of hospitals, clinics, schools, other civilian and humanitarian targets, including civilians who have gathered to receive international relief. Disruption and destabilization of the communities of internally displaced persons, people who have left the war zone. And widespread persecution on account of race, ethnicity, and religion. And it struck the committee that taken individually, each of those actions is a disaster for its victims. But taken together, they threaten the destruction of entire groups. Now, as a group whose mandate is to combat genocide, one of the first issues that we confront is, can we say this is genocide or not? And I know I'm in the presence of distinguished experts on that question. And we could have quite an academic discussion about whether it's the requisite intent when the government arms an ethnic militia knowing that it will fight another ethnic group with tremendous loss of civilian life in both of those groups. Does that reflect the intent to destroy either of those groups? This question of the obstruction of food aid to areas in war zones in time of famine which itself stemmed from war and human rights violations, where the government ostensibly is acting to prevent food from getting to rebel groups. Does that reflect the requisite intent? There are many, many questions that are posed as to the issue of whether genocide is there or not. And I think that as an initial step, one thing that we have tried to do is to set aside that. Set aside what sometimes I feel is a fetish with the issue of genocide, whether something is genocide already before we feel that we have a requirement or an imperative to respond. And so the Committee on Conscience has concluded that when you look at the scale and the scope of the violence there, deaths amounting to 1 in every 5 people within the region of southern Sudan, that we can leave aside the debate of whether it is genocide, and we can say that the threat is there, and that the point is to try to prevent genocide, not engage in a fruitless and self-defeating arguments about whether something quite meets that definition yet. So the Committee on Conscience has taken up the question of genocide. Let me, can I put in a plug for a program that we're going to have on November 15th for those of you who will be in Washington or can come to Washington. We are unveiling a display, an exhibition on the situation in Sudan with a public program in the evening. It will be a panel discussion, and it will be the first of a number of events where we will really, in a systematic way, try to fulfill the mandate of the Committee on Conscience to alert the national conscience to what's happening there. The issue really is, how do we connect the reality of what is happening someplace very far away, something that's not on the front page of the papers? And I think that if you look back at the history of situations that Samantha has gone over for us, that Sudan ranks on the end of the continuum where there is relatively little consciousness, relatively little identity with what's going on. And the issue is, how do you connect the reality of what's happening over there with the sentiments that are carved in stone on the wall of the Holocaust Museum, and impel a meaningful response by our government and other governments, setting aside what that response should be. And I think Samantha's very right in pointing out that there's a range of responses, and that it doesn't necessarily imply military intervention. How do we convert the pity that I think most people would share upon learning of the facts of Sudan into outrage, and then harness that outrage into effective action? Well, I don't have the answer. Perhaps somebody does, although no one's really come up with it yet. One way is, of course, to link what's happening to a current concept that we hear a lot about, which is the strategic national interest. But in Sudan's case, the connection to a strategic national interest may be difficult to get. Another way is to find some lower level of commonality than just the shared humanity that we have with the victims of the catastrophe in Sudan. And there are groups that are working very hard on doing that. For example, in the United States, Christian groups have gotten, a number of Christian groups have gotten involved in Sudan on the basis that many of the victims of the violence in Sudan are Christians. But there's a limit to how far that can go in terms of impelling a response. There's always the resort to historical analogy, which I find a very dangerous one, and one that I think as often works against impelling a response as it does working for a response. It's something that we're very, very cognizant of at the museum. And we don't base the work of alerting the national conscience on analogizing to what's gone before, but rather on the basis that the principles we can derive from what we learn from history is what should compel us to act. I think for our part, what we hope to do, as I mentioned before, is to amplify the voice of conscience, to change that balance, where the calculus too often is based solely upon questions of interest. We want to insert into that calculus issues of conscience. I would be the first to recognize that that will probably never be enough to compel action, but it does help change the balance. Another thing that I think is very important, and that I imagine we'll hear more about from both Payam and Pierre, is the importance of law and the development of law. Diane Ortlicker has referred to the law of genocide and crimes against humanity as the law of universal conscience. And there are many different ways in which establishing and developing, and now in the last few years, in some cases enforcing that law, helps give weight to the conscience on which that law is based, and helps, again, change the political calculus to some degree that Samantha has talked about, by giving increased weight to questions of conscience. I'd like to conclude by going back to words that are on the wall of the Holocaust Museum, ones that actually didn't come from any president of the United States, but came from the book of Isaiah. It's "You are my witnesses." And this is in the Hall of Witness at the Holocaust Memorial Museum. You are my witnesses. And I think that this passage works on several levels. Most obviously, it is saying to visitors to the museum that by visiting they are themselves becoming witnesses to the enormity of the Holocaust. It also echoes the explanation that General Eisenhower gave for insisting on visiting camps after their liberation at the end of World War II. "I made the visit deliberately," he said, "in order to be in a position to give first-hand evidence of these things, if ever in the future there develops a tendency to charge these allegations to propaganda." Witness, in other words, protects against the distortion or denial of history. But finally, this works as an admonition. It is written in the present tense. It implies a continuing obligation on all of us to bear witness to the crimes of today as well as the crimes of yesterday. And more than an admonition, it's a challenge. It's a challenge to move from witness to action. And that's the challenge that the Committee on Conscience is going to attempt to meet. And it's a challenge that I think more and more in the years to come is going to be at the heart, a very important part of the mission of the Holocaust Memorial Museum.
Thank you. Thank you, Jay. Let's now turn to Professor Pierre-Richard from the Lindh University, formerly visiting professor at Yale, and most importantly for today's purpose is the first legal advisor to the International Criminal Tribunal in the former Yugoslavia.
Thank you, Mr. Chairman. I'm going to speak today about some of the personal impressions I've had over the past several years of dealing with the question of genocide in the work of the Prosecutor's Office of the War Crimes Tribunal. And the word which I picked up on really in Jerry Fowler's presentation was his reference to the fetish of genocide. Given the fact that I'm an expert in fetishes, I'm going to concentrate on that subject. I've been really intrigued by the way in which genocide has, beyond its legal definition, a meta-legal meaning, and that this meta-legal meaning, which very often equates genocide with the ultimate crime, or the pinnacle of evil, how this privileged normative status of genocide has given rise to a certain competition over its use, and how this competition has affected the jurisprudence of the Yugoslav and Rwanda tribunals. And I would like to consider and question whether this preoccupation, at times obsession, with whose suffering is worthy of being categorized as genocide is necessarily a good thing, and what it says about the way in which we respond to such overwhelming realities. Firstly, any of us who are familiar with criminal law, or indeed the nature of legal systems, will know that there will always be a sort of stratification of evil in order to attribute differing degrees of liability to conduct which implies differing degrees of moral blameworthiness. So we will have murder in the first degree, murder in the second degree, voluntary manslaughter, and so on and so forth. And this is the way by which the law functions in the attribution of liability. Another characteristic of any legal system is finality. At the end of the day, a legal system is not concerned with broader historical or philosophical meaning, but simply whether, in the context of a criminal proceeding, a particular individual is guilty or not. There has to be a finality. Upon appeal, one cannot say, well, I think you're guilty for the time being, but I may reconsider tomorrow. Now, these two attributes of legal discourse, one, the stratification of evil, and the other, finality, make it particularly attractive to closure, make it particularly attractive to the conclusive, all-embracing definition and resolution of a problem or horrifying reality that we find overwhelming, unmanageable. So we try to reduce it in the antiseptic confines of legal discourse, and it makes us feel much more secure that we have somehow dealt with the situation. I would like to suggest that the impulse behind the Genocide Convention, at least in part, was this use of, if you like, a legal ritual to restore equilibrium in a moral universe that was overwhelmed by the unprecedented evil of the Holocaust. Raphael Lemkin, other than acting as a jurist, obviously was very personally affected by the Holocaust, as Samantha mentioned in her presentation. Virtually his entire family was exterminated during the Holocaust, and in his unpublished autobiography, he speaks about his crusade to push for the adoption of the Genocide Convention as a tribute to his parents and those who were perished in the Holocaust. One also sees in the preparatory works of the Genocide Convention, in the comments made by the delegates, this idea that this convention is somehow a monument, if you like, to an expression of protest, a further stigmatization beyond Nuremberg and the war and so on and so forth, of the unprecedented crimes of Nazi Germany. The inextricable association of the crime of genocide with the Holocaust and its elevation, if you like, to the rank of the ultimate crime, beyond the sort of legal stratification which I mentioned, very quickly turned it into a coveted possession. A coveted possession in the sense that those who could appropriate the term could then situate their suffering, their plight, their struggle, not to the mere rank of yet another atrocity, but to give it somehow a privileged position. At one end, we had those who were proponents of the uniqueness of the Holocaust, who suggested that this expansive trend somehow would dilute the enormity of the Holocaust and, in a sense, belittle it by applying the term genocide to anything that was really awful. And indeed, at one other end, one saw that people would use the term genocide to describe everything from abortion to birth control to racial mixing and all sorts of other uses of the term that most would agree are entirely inappropriate, leaving aside the legal definitions. In the middle, one had a number of ambiguous situations. The case of Cambodia was mentioned, for example. I had occasion to give a course to a group of Cambodian officials in Phnom Penh about international criminal law in relation to the Khmer Rouge crimes. I was really impressed, I shouldn't say the word impressed is probably not appropriate, but I was struck by the reaction of people when I explained that the overwhelming majority of crimes committed by the Khmer Rouge would not qualify as genocide because political or social groups are not included in the convention. There was a sense among the people, but it must be genocide. It must be ranked as one of the great evils of our time, or else we're somehow undermining its gravity. Similarly, in Guatemala, there were Mayan groups who insisted that the only accurate description of what they had experienced, not so much in legal terms, was the word genocide. And it was very important for them, apparently, to have their historical plight characterized in those terms. Now, how has this apparent competition over the use of the term genocide influenced the jurisprudence of the Yugoslav and Rwanda tribunals? I believe that it has given rise to two apparently contradictory tendencies, but I believe that these tendencies are both part of the same conception, inflated conception of the law, not simply as an instrument of attributing criminal liability, but the view of the law as somehow attributing events with a deeper significance and meaning, with the view of the law as a form of closure, as an official historical record, which attributes value, in a sense, to a people's suffering. On the one hand, there is a tendency to say that anything that is terrible must be genocide. And for the sake of brevity, I will have to simplify what are otherwise complicated legal issues. In the Akayesu case, one, and in general in discussing whether the situation in Rwanda constitutes genocide or not, and my friend Pierre Prosper, who litigated that case, can possibly comment on this further, one sees a tremendous anxiety, fear over the prospect that what occurred in Rwanda could be categorized as anything other than genocide. What is the problem? The problem, to make a long story short, is that the Tutsis were the victim group, were for the most part a social group. They were the aristocracy in Rwanda, and during the 19th century, in the context of 19th century European racialist theories, the sophistication of the Tutsi ruling class led the colonizers to formulate the theory that in reality they were not the same race as the subjects being the Hutu group, but in reality they were Hamite Semitic peoples who had migrated from Ethiopia as a superior race to rule over the inferior Bantu, and all of this racist mythology. Over time, this myth became a sort of socially constructed reality in the minds of Rwandese society, to the extent that when the Hutus were exterminating the Tutsis and throwing their bodies into the river, they would say, "We are sending you back to Ethiopia, where you belong. You are an alien race." The point is that the Hutus and Tutsis speak the same language, share the same religion, essentially have the same identity. Some would argue that they have different physical, racial characteristics, which is questionable at best, because it was possible through marriage, through accumulation of property, for Hutus to become Tutsis, and so on and so forth. Now, what is the problem here? We have the killing of 500,000 to 1 million people, one of the greatest mass destructions of the 20th century. And there is this tremendous anxiety, oh my goodness, what if they're not a protected group? And the court devises creative legal arguments, which I would say are somewhat questionable. Now, in other decisions such as Kaishima, the court takes a more sophisticated approach. In the Akayesu case, the court simply says, despite the exhaustive enumeration of protected groups in the Genocide Convention, despite the fact that criminal law must be interpreted strictly and all ambiguities must be resolved in favor of the accused, the court says that, well, the intention of the convention was not just to include the groups that are listed, but any similar groups that have stable characteristics. Whereas the Kaishima report decision takes a more sophisticated approach and says that, well, ethnicity, after all, is a social construction anyway, so if they considered each other to be different groups, then that is sufficient. That is perhaps a more plausible argument, but even there comes the question of whether crimes have to have some objective attribute. Now, leaving aside the question of whether what happened in Rwanda is genocide or not, and I don't intend to say that it's not, I think that is not the issue. The issue is, why is there such an angst to characterize it as genocide? And we see in the references to the debates about whether Rwanda is a case of genocide or not, and therefore whether we should intervene or not. Does this mean to say that, for example, in Sierra Leone, where for 9 years, Fode Santo and the RUF have been drugging children to kill their own parents, and where they've been amputating the children's limbs, that because one cannot attribute genocide to that situation, that it is somehow less worthy of our attention. Therein lies the danger of abstracting realities which on their own face, I think, tell the story adequately, and becoming obsessed with this removed, often antiseptic sort of legal debate and discourse, which has its own place, but which, if exaggerated, I think can actually steer us in the wrong direction. Another example of how this meta-juridical obsession, if you like, with the privileged status of genocide and whether a particular situation is worthy of the appellation of the ultimate crime, is the unfortunate decision in the Yelisic case for the Yugoslav tribunal. To make a long story short, Yelisic was a camp commander, if you like, occasional killer, who called himself the Serbian Adolf. He went to Berchko municipality, according to his own confession, to kill as many Muslims as he could. He confessed to having killed up to 150 people himself. He called the Muslims derogatory racist terms such as Turks who breed like rats, and so on and so forth. And in Berchko municipality, from approximately 3,000 Muslims that were not deported in an initial wave of ethnic cleansing, about 2,000 were exterminated. Now this, to me, would be a casebook example of genocide. Yelisic confessed or entered a plea of guilty to crimes against humanity, but not to genocide, which is very interesting. He says, I have committed evil, but not genocide. The prosecution decided nonetheless to go ahead with the case because it was important, both as a strategic matter of constructing the broader theory of what had happened in Bosnia, and as a matter of principle, to prosecute it for genocide. The court expressed its irritation, in part possibly because it had a busy docket, and in part because Yelisic to them was not really the superstar villain like Radovan Karadzic or Ratko Mladic or Slobodan Milosevic. He was just a camp commander. The court entered a judgment of acquittal, which means that when the prosecution completed its case in chief, the court threw the case out even before the defense had begun presentation of its case, on the grounds that not even a prima facie case had been established. And of course, the reasoning of the court is very unusual. It acknowledges all of the facts which I've described, but in the end says that Mr. Yelisic had a disturbed personality, and he committed the crimes not out of an intent to destroy the Muslims as such, but because of narcissistic desire to exercise arbitrary power, some other obscurantist argument, which suggests that genocidal killers on the whole should not lust for power and should be perfectly mentally balanced individuals. So much for indicting people for genocide. Now, what I believe underlies this case, and I have my reasons for believing that these are the motives of the judges, was that Jelicic was not a befitting spectacle for the first ever genocide conviction before the Yugoslav tribunal. We want the big Adolf, not the little Adolf. Yet many would argue, for example, that the Demjanjuk prosecution in Israel probably brought the realities of the Holocaust much more adequately to the eyes of the public than the Eichmann trial did. Because Eichmann was this nebulous bureaucrat involved in the extermination of 6 million Jews. But the case of Demjanjuk perhaps explained the daily realities of what it meant to be in these camps. In any event, I'm demonstrating here how this meta-juridical debate over ownership or appropriation of genocide has unfortunately influenced the jurisprudence of these tribunals. And one can contrast this with the relative self-restraint and attempt at objectivity of the Eichmann trial. And of course, we know that Judge Landau, the presiding judge in the Jerusalem District Court, himself was a Holocaust survivor. It makes one question, why are judges who are twice removed from these realities, and who one would imagine would be more impartial, so much more preoccupied with this question than, let's say, Judge Landau in the Eichmann trial? In conclusion, I'd like to suggest that there are 3 elements which we should consider in understanding this jurisprudence. And I'm not suggesting by any means that this characterizes all of the jurisprudence, but I believe there are these tendencies which we should be aware of. First of all, by suggesting that suffering that is so immense can be reduced to nice, neat, rational, manageable concepts, I think is the best way of trivializing human suffering. I think it does very little to humanizing our discourse by suggesting that, yes, this problem has been processed, packed away, we can put it on the shelf and strike it off the agenda. There must be, as Saul Friedlander says about understanding the Holocaust and other such crimes, we must resist the temptation to closure, even if we try to work through and understand the magnitude of the suffering. Secondly, I would like to suggest that a preoccupation with these abstractions actually may paralyze our will to act. That the obsession with universalizing legal language may, in certain respects, remove us so far away from the reality, from the context in which these crimes occur, that we may not necessarily get more action. And Warren Christopher, of course, had said at the end of the outcry over the failure to use the term genocide, he said, if there's any special magic to calling it genocide, please go ahead and do so. So would there have been any considerable difference if Rwanda was indeed called genocide? Finally, one aspect of this discourse which particularly concerns me is the appropriation of other people's suffering, the exploitation of other people's suffering for the demonstration of one's own virtue. Elizabeth Spellman has written a wonderful book called The Fruits of Sorrow, and I quote the closing statement in her book when she says that suffering is an arable field in which some do the hard work and others arrive just in time for the harvest. You do the, well, she says, you sow the seeds, I pluck the fruits of sorrow. I think it is essential that in adopting supposedly progressive stance in jurisprudence or in discourse, that we do not succumb to the temptation of appropriating other people's suffering as a means of demonstrating your own virtue in a way which further stills the voice of victims and further disempowers them. Thank you.
Thank you. We'll now turn to Pierre Prosper, who is the Special Counsel and Policy Advisor to the U.S. Ambassador for War Crimes at the Department of State. Hopefully not the author of any memos or guidance to the Department of Defense.
No, not at all. Actually, one thing I should probably make clear from the outset is that today I'm here speaking in my private capacity, but I'll be able to share some of my experiences and thoughts not only in my present job, but also as a prosecutor with the International Criminal Tribunal for Rwanda. I think what I want to do is I want to begin by building upon what has been said by the three speakers that went before me, for the simple fact that they covered a lot of what I wanted to say, so I'll just try to elaborate a bit. I think what we're seeing, what's becoming clear here, is that there is confusion emerging over the use of the word genocide. There's a legitimate question out there as to whether we are basically talking about a legal term or a political term. And I think something that we need to recognize from the outset when we're dealing with international law or international justice is that these issues go hand in hand with politics. So at times it is extremely difficult to separate one from another. When we look at the Genocide Convention itself, I think on its face and in fact in substance, it's clear that it is a legal instrument. It is one that criminalizes the offense. In fact, the parties agree that the crime of genocide, or genocide, is a crime under international law. It gives substantive acts and offenses. It provides a specific intent requirement, and it also calls for legislation by states that will invoke penalties and rules for extradition of individuals who are found guilty of genocide. When I was with the Tribunal for Rwanda, we looked at it as such, as a legal instrument. We chose to interpret it broadly, given an expansive and flexible definition, not only for the case which we had before us, but also not to narrow it in order to allow the document in the Genocide Convention to be able to apply to situations in the future that we just cannot imagine, could not imagine at that time, or cannot even imagine today. Paya mentioned the angst that existed in the Akayesu case, and I think there was a certain degree that did exist. And I think for the simple fact of that we were doing this for the very first time. In the past, we were looking at essentially writings from scholars, statements from diplomats. I researched Mr. Lemkin's work to see exactly what his thinking was at the time. So what we had to do at this time, we had to, in our own minds, come to a determination, what does it mean, and try to articulate it to the public. Articulate actually to the court and the document, because we knew that this document, the judgment, would be used in cases that were to follow, such as the Kaishima case and the case in the former Yugoslavia. So if the judge or the judges took pains to articulate in detail the law, their analysis, or their approach, I think it was for that simple reason. And I think something we must understand is that it will be refined over time. This was just a beginning point. But what we can see, and I think it does apply in the ICTR and the tribunals, is that there is pressure that comes from the outside when making a legal judgment on the issue of genocide, and even for crimes against humanity or the other crimes. And that is because when we look at the Genocide Convention, another significant component of the convention is its political aspect. It was created in a political forum. There were diplomats that came together at the UN in order to draft and sign this convention. It calls for action by the United Nations to prevent or suppress the conduct. And it also calls on states to take an undertaking to prevent or to speak out, whatever it may be. So what it is doing, in a sense, it's calling upon states to make a political determination that genocide exists in order for action or reaction to take place. And I think we all know, we've all looked at the Genocide Convention, and we know that there are some nuances there, and it's not as clear-cut as it may seem, primarily because we have this intent requirement. And in order to fully appreciate that genocide is unfolding or genocide is taking place, you really have to get inside the mind of the perpetrator. At times there may be facts, and the facts may be clear and apparent, and it's obvious to all that it is genocide, as it was in Rwanda after some time after it unfolded. We learned more, we knew what the radios were saying. But it is not always that obvious. So what the danger becomes when we have a document that has a political component is that the crime itself will become politicized. And I think this goes a bit into what Payam was speaking to. If we look to the past, 10 years, since Rwanda essentially, the word genocide is being thrown around and used very liberally. Some of it may be for what Payam said, is that people are trying to, there's an ownership issue. People want to say my suffering is as bad or worse than your suffering. But there is also an angle to it where that there are people who are trying to take what I would call a political, or gain a political advantage by using the word genocide. And by avoiding and by not essentially using or taking a legal approach and a legal analysis and using it in a political forum, the word genocide is beginning to lose its meaning, it's losing its legal significance, and the crime itself is being diluted. Let me give you a few examples. Payam did discuss Cambodia. I too spent some time in Cambodia, and I had discussions on this particular issue. As some of you may know, there are efforts underway to create these extraordinary chambers in Cambodia to prosecute the Khmer Rouge for the crimes that occurred during the Pol Pot era. And when that statute was being drafted, the issue of whether or not to include genocide came up. And of course, it's in there now, but it was, as I would say, essentially a political decision by some individuals to put it in. And I think it is partly for the reasons that Payam has articulated here today. Because the word has taken on such a new meaning, people feel that it has to be in the statute. My crime needs to be called genocide because a lot of people died. Let's forget about the intent. We don't need to go that far in the analysis to see if there was an intent to destroy in whole or in part. A lot of people were killed, a lot of people suffered, therefore it's genocide. It's going to be in the statute. And the danger here, when we're taking this approach, which we see in other parts, which I'll get into, parts of the world, is that it puts pressure on the courts to look hard for genocide. It puts pressure on the prosecutors to push for a genocide case when a genocide case may not exist. Because now there is a political expectation, because of a political decision, that genocide exists in a particular conflict. And that is extremely dangerous, and it challenges the integrity of the law itself. We also saw this a year ago in the Kosovo situation. Immediately after the conflict began in Kosovo, and we saw the crimes that were committed by the Serbs against the Kosovo Albanians, the word genocide was on every news program, being used by every person who talked about the issue. Some politicians even came out and said, it is a genocide, we must take action. We need to question at times the motivation for this. Is it because people feel that if you use the word genocide, the international community must respond with military force? Or is it because they just did not understand the term? But that was a problem out there. And as we saw, as the conflict evolved, it was a bit of a walk back. You saw people using the term less and less because they realized that it was not something that you could easily label in a political decision made in a room on one day. It is truly a legal analysis that is the result of investigations. And just on an aside, when I prosecuted my case with the Rwanda Tribunal, we investigated the case for at least a year and tried the case for over a 14-month period before there was that conclusive proof before a court that a genocide had taken place. So I don't think we should expect governments to make that decision in 1 hour or in one boardroom or cabinet meeting. And I don't think we should even ask for it, because in my personal opinion, it's dangerous. We should just look at the facts, look at what is happening on the ground, and decide what we as a global society will do at that point. We can also look to East Timor. A similar situation last year. Immediately after the violence broke out, there were some people in parts of the world that were saying it is a genocide that is taking place. The international community must come in and must react and must do something about it. And there, at the end of the conflict, we saw that approximately maybe 1,000 people were killed. And it will be questionable to see what the prosecutors at the time, what they charge, if they choose to charge a genocide case. I don't think it will happen, but you never know based on some of the pressures that exist. The charge is now in their new statute on the East Timor UN operation. And one thing I want to say, I have to go back to Kosovo for a second, something that proved my point. When the former Yugoslavia indicted Milosevic for the events of Kosovo, they did not indict him for genocide. It was crimes against humanity. So I think this is some of the difficulty that we're seeing. I think the term is being used as political leverage, and not only so that societies can say that my suffering is worse than yours. This issue has essentially reared its head again this week. Some of you may be following the events in Zimbabwe. We know that currently the president of Zimbabwe, Mr. Mugabe, is being challenged politically. He's been seizing land. There's opposition parties getting stronger. And recently, articles of impeachment were filed. They really want to remove him from office. Polls show that he 50-some-odd% of the population feel he must step down. 50% of the population or so feel that he has committed human rights abuses. Mugabe, threatened by this, has taken action. And I'll read to you excerpts from an article that came out yesterday. The headline is, "Impeachment Motion Prompts Mugabe to vow arrest of ex-leader." And the leader here is a former white Prime Minister, Rhodesian Prime Minister, Ian Smith. Mr. Mugabe has decided to revoke the policy of reconciliation that's been in existence for 20-some-odd years. And yesterday he said, Ian Smith and the whites who participated in the massacres and genocide of our people who fought against us will stand trial and be tried for genocide. Now, I'm not sitting here diminishing what the Rhodesian government did. We have to recognize that there was oppression, discrimination, abuses. But the question is it genocide? We have to be careful that we do not rush to judgment on this particular issue. And to show how the term is becoming more diluted and people are not taking this as seriously as one should, there was a subsequent article. It was essentially a response from Mr. Ian Smith. And Ian Smith, the headline says, Ian Smith laughs off genocide trial. I mean, he laughed it off. Is this where we want to be, that we're laughing off the term genocide or the prospects of a trial? Mr. Smith says he welcomes a chance to confront that gangster, Mr. Mugabe, over corruption and nepotism of his presidency. Quote, "I've been waiting to meet this chap for 20 years, but he has refused to talk to me. I'll give him the date of my return and my flight number, and he can meet me at the airport with the red carpet. I welcome this trial, so let's have it." It is now, as we see, it is an issue or a topic that is being used for purely politics, as opposed to describe the seriousness of the events and to go back to the original intention of its drafters and Mr. Lemkin. Again, I think what we need to do now, in order to avoid having an adverse impact by throwing the word around loosely, is again not rush to judgment. We should allow the courts to determine whether or not something is genocide, rather than a court of political or public opinion. Thank you.
about 10 minutes for questions, answers, and comments. Please state your name and association.
Hi, Diane Amon from the University of California at Davis. A couple of things. I think Mr. Prosper mentioned Milosevic right at the end, and I think that the indictment of Milosevic was a classic example of some of the things that he talked about in that in the lead of the article on the indictment said what many of the indictments on the International Criminal Tribunal have said, which is not just Milosevic was indicted for crimes against humanity, but Milosevic was indicted for crimes against humanity, but not genocide. And I think that that is indicative that it's not just the tribunals that are obsessed with the idea of genocide, but I think it's in the popular reality that, and it may be, perhaps it's too late to say we should reclaim the definition, because I think for the popular culture, certainly is reflected in media stories like that. If it isn't genocide, it isn't really, really, really bad. So I don't know how we deal with that, but it just struck me when I saw that. Professor Akawa, you mentioned in one of your three elements that you fear that one of the dangers of a preoccupation with abstraction with regard to the definition of genocide would paralyze the will to act. And I think that there is that danger, but I guess I have perhaps a somewhat more cynical view, which is that the manipulation of the definition of genocide is used as a mask for the actual lack of will to act or to react, which I think is reflective of what Ms. Power said, that, oh my God, if we call it genocide, we might have to do something. And I think that that's a lot of the problem. It's not so much that we as academics get caught in the abstraction, but that the political bodies have chosen to use the term in a way to avoid their international responsibility to prevent and punish atrocities.
Any quick response from the panel, or should we move on? Some more comments. We have a comment in the front row here, and then.
Mr. Chairman, I want to ask Mr. Prosper, does he consider that the United States is committing genocide by aiding and abetting Israel to commit genocide against the Palestinians?
Here. Put in your State Department hat.
Yeah, I guess now I'm out of my private capacity. Well, I think obviously everyone is troubled by the situation, what is happening in the Middle East. There has been an escalation of fighting, of tension and killings, and on the surface, when we look at it, the balance is not fair. Palestinians are being killed in large numbers. But again, I'm just going to go straight to the legal issue rather than the political issue of the United States. But again, this is an issue where do we rush to judgment and call it genocide? I mean, you have to look at the intent. Why is someone doing something? Is that they're trying to destroy the group, or when there is the fighting, is there fighting out of protection? Is the intent that we are protecting our borders where we've been assaulted?
But it's not the fighting now. They expel the Palestinians. They rob their homes and land. They are taking all the homes of the Palestinians and making them a refugee nation. This is a genocide against the Palestinians, and the United States is aiding and abetting Israel by money, by weapons, and political support to the United Nations. So it is not a question of fighting now.
Let's have about a 30-second response.
Yeah, I mean, just quickly, I think I would just have to challenge the characterization that what is happening there is in fact a genocide, and I think that's the best way to leave it.
Okay, right here in the second row.
I would like to try a short...
Stand up and name and affiliation.
Name is Jeremy Gunn. The short question I have is sort of the Emperor's New Clothes question, and that is, given what we've heard today, did the Genocide Convention actually do more harm than good? It creates a certain kind of inaction. I remember from the Senate debates on ratification that there was a question, if you have one lynching in the South of the United States, is that cause of genocide? So it's been legally debatable from the very beginning whether it can be limited, whether it's big. when it causes inaction, doesn't that mean perhaps the convention's done more harm than good?
Samantha, you track the history on this. You want to answer that?
Yeah, you know, a couple things. One, the Genocide Convention and category of crime, forgetting in the law itself, but the sort of whole notion, rhetorical and political, of genocide, it has had some positive effects. I work at Kennedy School, I went to the Carr Center there, and the notion of convincing realist strategists of the rightness of intervention is quite far-fetched in most humanitarian rights of humanitarian intervention is far-fetched, but virtually every one of them will make an exception for genocide. Similarly, if you look at poll data, this is a public matter, the general public, and I don't know that this is sustainable, but in 1994, when we had 2 instances of mass atrocity underway, the genocide in Rwanda and then the war in Bosnia, if you asked the American people whether they supported intervention, in the case of Bosnia, I believe the numbers were around, it was about 55% for airstrikes, relatively passive support, but support for airstrikes. When the question was posed as if an international commission existed that found that what was going on in Bosnia was genocide, would you support intervention? That figure rose to 75%. So it has a public force and a public oomph that is exploitable in the instance or in the event that we actually had leaders in power who were interested, not because it was genocide, but because it was wrong, and because it was stopping them to go and combat it. Similarly, in Rwanda, the number in support of interventions was very, very low. I think it was 43% or something, and that went up to 84% if a commission existed to find genocide. So, has the convention done any good? I think the only time it's really been employed is in these international tribunals and these prosecutions, and I don't know that it's had much effect even in sentencing. It has created, I think, as Jerry can attest, a normative consensus, or it has contributed to the propagation of normative consensus that a word alone, perhaps, just Lemkin with his letters from the Webster's Dictionary, the OED, that wasn't going to be enough. He sort of had to get it instituted, in an institution. There have been domestic trials around the world, but as a political matter, as a device to secure military intervention, the 3 interventions we've had to stop genocide, arguably in Bangladesh, in Cambodia, and in Uganda, it had nothing to do with the Genocide Convention and everything to do with border skirmishes and interests.
Okay, we have time for 2 more quick questions. Let's take them together and then have Al respond.
Thank you. My name is Pierre-Richard. I'm a law student. I have a question directed to Ms. Power. How do you define what is a political and or a social group when the case involves a religious or ethnic minority that is seeking asylum? I'm specifically referring to the Sikh system, John Lewis, political and being a religious minority.
While you're contemplating your answer, Sam, let's take Ben's second question.
My name is Ben Ferenz. I witnessed genocide. I knew represented it. I looked into the eyes of those who committed genocide. I prosecuted people who committed genocide. I committed the shortcomings of the American legislation. I compliment all of you that we raised these problems, points of view, and the difficulties of dealing with this concept. For example, I tried to compensate the victims of genocide, the survivors of genocide acts. We came into the problem, how do you measure death? How do you measure pain? How do you measure fear? These are concepts which you cannot really deal with in a legal framework. Wouldn't we all be better advised of looking rather to the evil that we caused, to go back to the conscience thoughts which Bayam has expressed, and the political difficulties that we have, and focus instead our effort to eliminate the causes that give rise to this type of massive killing by people who consider themselves usually idealists or people of intelligence or aiming for a particular goal. If we focus on the causes and try to eliminate the cruelties that go with that causes, wouldn't it be a simpler approach to the problem?
Sam, why don't you answer a specific question, and I'll see if there are any takers on the problem.
Sure. I also think the others would probably be better even on this question. The way that in the drafting sessions for the Genocide Convention, the way that political and social groups were excluded the argument was that it was a mutable category, that people could change their political opinions and their social affiliations, whereas ethnic groups and national groups were descriptions that you were born with and couldn't shake. There was an argument, a refutation of that by saying, well, what about religion? Well, you can change your religion. But I think, often you have what you're describing, which is religious, ethnic, and national groups who also possess certain political aspirations, and that's usually why genocide happens, and one of the justifications that perpetrators use to commit genocide. I think the danger, and one of the things that people do on the outside in order to justify looking away, is to to internalize the perpetrator's intent, to say, if the perpetrator is killing people because of their political aspirations, then that makes the group necessarily a political group, when in fact, they're looking to just basic sort of self-determination. But again, I think the lawyers, practicing lawyers would have a better sense of that, perhaps, in jurisprudence.
Comments on that, or any closing comments with Ben's comment in mind?
I'm really grateful for the comments of Mr. Perez. The point is that something as enormous as genocide, mass killing, requires tremendous effort to understand, yet even more effort and sacrifice to confront effectively. And it's much easier in a culture of instant gratification and we have an agenda and let's strike it off, to just engage in these legal abstractions. Okay, we've processed this legally, the problem is gone. So this is a reflection of a broader cultural view of suffering, pain, sacrifice, commitment to confronting evil. I think that there are I just want to make one big point, that there's a difference between existential questions of how we relate to this kind of evil, as opposed to strategic questions, but the two are not unrelated. So one could say that in a world which has so banalized evil, which is so obsessed with the culture of violence on television and whatever, that we have to exaggerate things to get people to do something, then we may have to on occasion make those compromises. But I think we should be very cautious to give in to that culture in making these strategic compromises. And I want to end by just giving one example of what I'm talking about. I was working in Bosnia during the war for the Human Rights Commissioner, Tadeusz Mazowiecki. And the Warburton Commission, which was a European commission, met with some officials and came up with the figure of 20,000 women who had been raped in Bosnia. And of course, this was part of the propaganda war, which was not a question of has rape occurred or not, but what was the scale. We had a group of experts, statisticians, and so on and so forth, who did a thorough study of the question, came up with a much lower figure of 4,000 or 5,000. There was outrage. Only 4,000 or 5,000? We're not interested in 4,000 or 5,000, we're interested in 20,000. That to me is a complete dehumanization of the victims and is catering to a cheap sensationalism which says, well, is it newsworthy or not? And why should somehow a genocidal rape be more important than simple rape? What does this say about how numb we've become to other people's suffering? And in that sense, I think this can paralyze our will to act because it removes us so far away from reality.
With that, please join me in thanking our panelists.